Can you keep the house if you're the executor? Do you need a real estate agent? That's our topic today. We'll get started right after this. So you may be wondering, can you keep the house if you're the executor? And do you need a real estate agent? This video is based on an actual question from a personal representative and executor that is subscribed to our channel. The executor's actual question was, if your loved one died without a will and you went to the probate court and was appointed as the executor of everything, but you want to continue to live in the home, can you still do that? She continued sharing, I have my own home, still paying my mortgage, but my parents' home is worth way more than mine and is much bigger. How would I keep the house? Can it be switched to my name? I always see about people wanting to sell probate real estate, but not for people wanting to keep it. So this was my answer. Good question, and it depends. Are you the only beneficiary of your loved one's estate? If you are the only beneficiary of the probate real estate, then theoretically, the decedent's property will be yours. Regarding having the deed in your name so that you can keep the house, that might be possible once the probate is complete. If there are other beneficiaries, you would need to buy them out of the probate real estate. I recommend you speak with your probate attorney regarding you wanting to live in and keep the house. Hi, I'm KimWard. I'm a real estate broker here in beautiful San Diego, California, and my team and I have been helping trustees, executors, administrators with homes in probate or trust administration. We've been gratefully helping personal representatives for almost 2 decades, and that's why we created this channel, so that we can pass on all the knowledge that we've received over these past 20 years. I hope you find this of value. Now let's get started again. So let's go a bit deeper into the question. Can you keep the house if you're the executor? Do you need a real estate agent? We live in an imperfect world, which means siblings rarely agree on everything. Couple that with the emotional toll of losing a loved one, and the tensions may run even higher than normal. Inheriting probate real estate can be a blessing, but when you're inheriting that home with one or more beneficiaries, it can also create some difficult emotional terrain, which can lead to both financial and emotional stress for everyone involved, especially if, as the executor or administrator, you want to keep the house. Unless there is a will that explicitly states otherwise, inheriting a house with siblings means that ownership of the property is distributed equally. The siblings can negotiate whether the house will be sold and the profits divided, whether one will buy out the other's shares and keep the house, or whether ownership will be continued to be shared when keeping the house altogether. Involving the San Diego Probate Court is a last resort for most people. But if you as executor and your siblings can't reach an agreement on whether to keep the house or what to do with the property, then a partition suit may be needed. Partition lawsuits ask the probate judge to order the home sale using a certified probate real estate agent in order to determine the co-ownership. But the legal process is rarely that simple. Most likely, the probate judge will require a mediator to mitigate conflicts between the co-owners. This person can be referred to as the referee, and of course is an additional expense on top of what you'll already have to pay, such as a real estate agent to sell the probate real estate. You may even need to hire an accountant to divvy up the proceeds, which can seriously limit your profits. That they're going to be needed to be divided equally or even unequally. Even if one person owns a higher percentage of the property, all owners have a claim, meaning no one individual can claim ownership over it. Now let's talk about structuring a buyout. A lot of probate real estate are inherited equally. So unless otherwise stated, 2 beneficiaries likely have a 50-50 ownership of the probate real estate. If one sibling wants to buy out the other and keep the house, this means they would need to finance half of the home's value. The most important part of this process is having a home appraisal, which will determine how much the probate real estate is worth and therefore how much the executor or administrator who wants to keep the house would need to pay to buy out the other beneficiaries. Once the probate real estate's value is determined, the other beneficiaries can be paid for their share and transfer the deed into the executor's or administrator's name. Now, of course, I'm talking as if for sure it's the executor or the administrator that wants to purchase the house, but of course, if the beneficiary wishes to keep the house and the executor or the administrator doesn't, the same information applies. I imagine the next thing you're wondering is, can you refinance the probate real estate to buy out the other heirs? And do you need a real estate agent to help you with the entire process? Some conventional lenders typically don't offer this type of refinancing, and when that's the case, hard money lenders are also an option when you want to keep the house. A hard money loan is a short-term loan provided by a non-traditional lender, such as individuals or private companies, that they accept the property or asset as collateral. These loans typically have a fast, less strict approval process that makes them a convenient option for executor or administrators who need to move quickly. But like with traditional mortgages, keep in mind that the probate real estate is held as collateral on the loan, which means defaulting may result in the lender taking ownership of the probate real estate. The other important thing to know is that hard money loans can charge a large upfront fee and equally high interest rate. Selling and dividing the profits, and yes, in most cases, you will need a real estate agent to help you to prepare, market, and sell the probate real estate. When the beneficiaries have agreed to sell the probate real estate or a home in a trust administration, the executor, administrator, or trustee do need a real estate agent. Your real estate agent or broker like me will prepare a pinpoint price analysis. With this information, along with the date of death appraisal, together we will determine the current market value of the property. With probate real estate, there are many steps and timelines along with the proper documentation that needs to be adhered to. Having a certified probate real estate advisor will be key to protecting yourself as the administrator or executor and also protect the estate. The bottom line, inherited homes often come with a lot of sentimental value, which may lead to beneficiaries disagreeing on what to do with the probate real estate. Whether you keep the house and wondering, do you need a real estate agent? Talking with an experienced San Diego County real estate agent would be one of your first steps. So if you've recently become involved with an inherited house with one or more siblings, it's important to understand your options so you can advocate for the well-being of everyone involved. Thank you for watching. Please, if you've taken value from this, go ahead and hit that like button, comment down below, and I'll see you next week.